mamá huevo, qué locura. Mosca ahí, mosca ahí. Mira esa mierda, explotaron allá toda esa mierda, porque tú no estás explotando.
I mean, what's interesting is under international law, even if the seizure was unlawful, there's a doctrine that says that as long as the criminal proceedings are conducted in accordance with due process, that is okay, right? And so the cases involving this generally involve people who have committed mass atrocities like Eichmann during the Nazi era. So there is this doctrine that says even if it was violating international law, it could still be okay if the domestic criminal proceedings are consistent with due process. So.
Good night. Good night. Happy New Year.
So from a U.S. law perspective, to sum up, the idea is that the Fourth Amendment and constitutional protections don't apply overseas. It was a military operation that didn't amount to war in a constitutional sense, so you didn't have to get congressional pre-approval. And all of the international law governing the use of force doesn't apply in a law enforcement context, right? So those are the propositions that the U.S. raised.
Late last night and early today, at my direction, the United States Armed Forces conducted an extraordinary military operation in the capital of Venezuela. Overwhelming American military power, air, land, and sea, was used to launch a spectacular assault. And it was an assault like people have not seen since World War II. It was a force against a heavily fortified military fortress in the heart of Caracas to bring outlaw dictator Nicolás Maduro to justice.
Extendemos la más cordial bienvenida a los representantes.
El 3 de enero del 2026 constituye una fecha de profunda gravedad histórica, no solo para Venezuela, sino para el sistema internacional en su conjunto. Ese día la República Bolivariana de Venezuela fue objeto de un ataque armado ilegítimo, carente de toda justificación jurídica, por parte del gobierno de los Estados Unidos de América. Venezuela es víctima de estos ataques por razón de sus riquezas naturales.
Then what about, for example, the United Nations Charter? Isn't the U.S. a signatory? And if the United Nations Charter applies, then do the international law prohibitions on the use of force apply as well? And the United States, in a memo dating from the Panama era, the Department of Justice has said and this is highly controversial, and I don't think they really need to go too much into detail, but that under these circumstances the United Nations Charter doesn't apply. And so that's been their argument, which is somewhat problematic. Yes, a sitting head of state normally has immunity from a criminal prosecution in another country. The issue here is the United States has never recognized Maduro, so the argument would be he is not actually a sitting head of state with respect to the United States. The other aspect of it, which is somewhat important and connected, is the indictment against Maduro, like the indictment of Noriega, has some allegations of drug trafficking as private activity rather than head of state activity. Although the current indictment also accuses Maduro of sort of deploying the state apparatus in the drug conspiracy crimes. And so what happened in the Noriega prosecution, which happened in Florida, was the head of state immunity offense wasn't raised by Panama. Noriega had a weaker claim to it to begin with, and the courts it went to the 11th Circuit, which is the appellate court for Florida, Georgia, Alabama in the southeastern United States, and the appellate court essentially said no head of state immunity, and for those reasons, and also because the activity that you're being accused of isn't head of state activity, it's sort of private criminal enterprises. So I think that should that happen, it'll play out similarly here. I should note that I should note that he pled not guilty, Maduro pled not guilty, and the indictment also charges his son and his wife. And his wife, Celia Flores, was abducted with him. So they'll stand trial together. I think their best arguments really are going to be they aren't guilty of narco-terrorism or conspiracy to distribute drugs. That secondary liability, the aiding and abetting, they don't have the right mens rea, all of those things, because in the U.S. criminal justice system, they have to be proven beyond a reasonable doubt. So I would think that rather than the head of state immunity defenses, which are more interesting from an international law perspective, they may seem sexier from that perspective, but they're probably not going to be a part of this case. And what we're going to see is just plain old-fashioned criminal lawyering and showing the prosecution having to show the evidence to back up each element of the crime and convince the jury beyond a reasonable doubt that they've made their case.